you know, in my 94 years of watching American institutions weather storms, both predictable and surprising, I've learned that the most consequential moments rarely announce themselves with fanfare. They arrive quietly, often buried in legal documents or technical proceedings that most people never read. But these quiet moments, these seemingly procedural decisions, have a way of rippling through the entire system, like a stone dropped in still water. I've spent the better part of a century watching how confidence moves markets, how trust anchors institutions, and how the slow, steady work of governance either builds or erodes the foundation upon which everything else rests. The markets I've known, the companies I've studied, the leaders I've observed, they all teach the same fundamental lesson. Stability isn't built through grand gestures or dramatic pronouncements. It's built through the accumulated weight of countless small decisions made by people who understand their duty to something larger than themselves. Leadership, real leadership, doesn't seek the spotlight. It works quietly, methodically, with an understanding that institutions are like carefully tended gardens. They require constant care, respect for established principles, and the wisdom to know when change serves the system and when it merely serves the moment. Over the decades, I've watched this country navigate periods of tremendous uncertainty. The Great Depression taught me about the psychology of fear and the importance of institutional confidence. Watergate showed me how quickly trust can erode when norms bend too far. The 2008 financial crisis reminded me that systemic risk often hides in seemingly technical details that most people ignore until it's too late. What I've learned is that America's greatest strength isn't its wealth or its military power or its natural resources. It's the quiet stability of institutions that have learned to bend without breaking, to adapt without abandoning their core principles. When those institutions work properly, most people barely notice them. When they falter, everyone feels the tremor. Today, I want to talk with you about one of those quiet moments that could reshape how American democracy functions for generations to come. It's not grabbing headlines the way a political scandal or a market crash would, but for those of us who understand how systems work, how confidence builds and erodes, and how institutional changes create ripple effects that extend far beyond their immediate scope, this moment deserves our careful attention. Before we examine this particular development, it's worth understanding the broader environment in which it's unfolding. American institutions today are operating under a level of strain that I haven't seen since the 1970 seconds. Not the dramatic headline-grabbing kind of strain, but the deeper, more concerning kind, the erosion of shared assumptions about how our system should work. In the markets, we call this confidence risk. It's not about whether a particular company will hit its quarterly earnings target. It's about whether investors believe the fundamental rules of the game will remain stable and predictable. When confidence erodes, even good companies see their valuations suffer because uncertainty creates a discount that affects everything. The same principle applies to democratic institutions. Elections, courts, legislative processes, they all depend on a shared confidence that the rules will be applied consistently, that outcomes will be accepted as legitimate, and that institutional boundaries will be respected. When that confidence wavers, the entire system becomes less efficient, more volatile, and more vulnerable to manipulation. I've been watching this erosion accelerate over the past decade. Each election cycle brings new disputes about procedures that were once handled through routine administrative processes. Courts are increasingly called upon to resolve conflicts that were previously settled through political negotiation or bureaucratic discretion. The technical details of election administration, ballot deadlines, signature verification, counting procedures have become battlegrounds in ways that would have been unthinkable a generation ago. This isn't about any particular political party or ideology. It's about a deeper shift in how we approach institutional legitimacy. When every procedural decision becomes a matter for litigation, when every administrative choice gets viewed through a partisan lens, when every technical requirement becomes a potential source of controversy, the system starts operating less like a well-oiled machine and more like a mechanism under constant stress. Foreign investors and trading partners have begun factoring this institutional uncertainty into their long-term planning. Not in dramatic ways. America remains the world's most stable large economy, but in the careful, measured way that sophisticated actors adjust their risk assessments when they sense that underlying assumptions may be shifting. The currency markets reflect this subtle recalibration. The dollar remains the global reserve currency, but its premium for institutional stability has narrowed slightly as international observers watch American political and legal institutions navigate unprecedented stress tests. It's not a crisis, but it's a trend that bears watching. What concerns me most isn't any single institutional conflict, but the cumulative effect of constantly questioning the legitimacy of established procedures. Markets can absorb individual shocks quite well, but they struggle with systemic uncertainty about the rules themselves. When businesses can't predict how elections will be conducted, how disputes will be resolved, or how institutional authority will be exercised, they begin making different investment decisions. Into this environment of heightened institutional sensitivity steps the United States Supreme Court, an institution that, by design, operates at a remove from immediate political pressures, but whose decisions ripple through every aspect of American life. The court's role in our system has always been to resolve conflicts that other institutions cannot settle, to interpret constitutional and legal texts when its meaning becomes disputed, and to provide final authority on questions that might otherwise fracture the entire system. What makes the Supreme Court unique among American institutions is its combination of enormous power and deliberate insulation from popular sentiment. The justices serve for life. They don't face elections, and their decisions can only be overturned through constitutional amendment or subsequent court rulings. This design reflects the founders' understanding that some decisions require protection from immediate political pressures. But this insulation also means that when the court acts, its decisions carry particular weight in terms of institutional confidence. Unlike congressional votes or presidential directives, which everyone understands as political acts by political actors, Supreme Court rulings are supposed to represent law rather than politics, constitutional interpretation rather than policy preference. The court's current composition reflects decades of political maneuvering by both parties to shape its ideological balance. But the institution's legitimacy depends on public acceptance that its decisions flow from legal reasoning rather than political calculation. When that acceptance wavers, when large numbers of Americans begin viewing court decisions as partisan acts dressed up in legal language, the entire system of constitutional governance comes under strain. This tension has been building for years. The court's involvement in the 2000 presidential election, its major decisions on health care and campaign finance, its rulings on abortion and gun rights, each of these has contributed to growing public perception that the court is a political institution rather than a legal one. The justices themselves seem aware of this challenge. In recent speeches and writings, several have emphasized their commitment to legal rather than political reasoning. But institutional legitimacy isn't something that can be declared. It must be earned through the accumulated weight of decisions that the public accepts as principled rather than partisan. This institutional context matters enormously for understanding the significance of the court's recent decision to hear a case that might seem on its surface to involve nothing more than technical details about ballot processing deadlines. When an institution under scrutiny for its political neutrality takes up a case with obvious political implications. Every aspect of its reasoning and every nuance of its eventual decision will be examined for signs of partisan motivation. On November 10th, 2025, with minimal fanfare and no public discussion, the Supreme Court issued a brief, unsigned order that could reshape American elections for decades to come. In just a few sentences, the justices announced their decision to hear Watson versus Republican National Committee, a case challenging the authority of states to count mail-in ballots received after election day if those ballots were postmarked by the deadline. The order itself was unremarkable in its brevity and formality. No justice dissented from the decision to grant review. No separate opinions explained the reasoning. No dramatic language suggested the case's potential significance. It was exactly the kind of routine procedural announcement that the court issues dozens of times each term. But within hours, this quiet institutional moment had transformed into something much larger. Legal analysts began describing the case as a potential blockbuster that could affect mail-in voting laws in 18 states and the District of Columbia. Political commentators started speculating about the implications for the 2026 midterm elections and beyond. Election administration experts began calculating how many voters might be affected if the court invalidates existing ballot receipt deadlines. The transformation from routine legal proceeding to national political story illustrates something important about how institutional decisions propagate through our current media and environment. The court's actual decision to hear the case was modest and procedural, but the potential implications of whatever the court might eventually decide turned that modest procedural step into a major news story. This pattern has become increasingly common in recent years. Technical legal developments that would once have been noticed only by specialists now become immediate political flashpoints because everyone understands that seemingly narrow legal questions can have enormous practical consequences. The gap between what actually happened, a routine grant of certiorari, and what people feared might happen, a dramatic change to election law, created space for speculation. Anxiety and political positioning that had little to do with the court's actual reasoning. What struck me about this particular moment was its quietness. There was no ceremony, no press conference, no dramatic announcement. The court simply did what it always does, added another case to its docket through the same process it uses for dozens of others. But in our current environment, even this routine institutional function becomes a source of national political tension. The case itself involved Mississippi's law allowing mail-in ballots to be counted if they're postmarked by Election Day and received within 5 business days afterward. The Republican National Committee and other challengers argue that federal law requires all ballots to be received, not just postmarked by Election Day. 18 states and the District of Columbia have similar laws that could be affected by the court's eventual decision. From a legal perspective, the case presents a classic question of statutory interpretation. What did Congress mean when it established a single national election day for federal elections? Does that requirement create a hard deadline for ballot receipt? Or does it simply ensure temporal coordination while leaving states free to accommodate the practical realities of mail delivery? But from an institutional perspective, the case represents something more significant. It forces the court to choose between competing values that go to the heart of democratic legitimacy: uniformity versus accessibility, legal clarity versus administrative flexibility, federal authority versus state autonomy. Now, you might wonder why a case about ballot deadlines would concern someone who spent his career analyzing businesses and financial markets. The answer is that institutional confidence, legal predictability, and democratic stability are fundamental inputs into every long-term investment decision. When those foundations shift, everything built on top of them shifts as well. Think about it this way. Every business that operates in America makes assumptions about political stability, regulatory predictability, and the peaceful transfer of power. These assumptions are so basic that most people never think about them consciously. But they're priced into every stock, every bond, every long-term contract, and every investment decision. When election procedures become unpredictable, when the rules governing democratic competition change suddenly, when basic administrative processes become sources of legal uncertainty, sophisticated investors begin factoring those risks into their calculations. Not dramatically. America remains one of the most stable political systems in the world, but measurably, the currency markets have already begun reflecting some of these concerns. International investors who have long treated American political institutions as essentially stable background conditions are starting to price in small premiums for institutional uncertainty. It's not a crisis, but it's a trend that reflects growing global awareness that American democratic processes face stresses that didn't exist a generation ago. What makes the Watson versus RNC case particularly significant from a market perspective is its timing. The court will hear arguments in early 2026 and issue a decision by late June, just months before the midterm elections. If the court invalidates mail-in ballot deadlines in 18 states, those states will need to implement new procedures under severe time pressure, creating exactly the kind of administrative uncertainty that markets find most difficult to price. Implementation risk is a concept that financial analysts understand well. It's the possibility that policy changes, even beneficial ones, will create temporary instability as institutions adapt to new requirements. In the case of election law, implementation risk is particularly acute because election systems require months or years to modify safely, but legal changes typically take effect immediately. The sectors most likely to be affected include state and local government bonds, election technology companies, legal services, and logistics providers. But the broader economic impact comes from the uncertainty itself, rather than any specific sectoral exposure. When basic democratic processes become less predictable, it affects business confidence across all sectors. I've seen this pattern before in other contexts. During the savings and loan crisis of the 1,980 seconds, the immediate financial damage was confined to specific institutions and regions. But the broader economic impact came from uncertainty about regulatory responses and the potential for contagion effects. Markets recovered quickly once regulatory authorities provided clear guidance about how they would address the underlying problems. The same principle applies to institutional uncertainty around elections. The direct effects of changing ballot deadlines might be relatively modest, but the indirect effects of increased uncertainty about democratic procedures could be much larger. Businesses making long-term investment decisions, international partners negotiating trade agreements, and financial institutions assessing political risk all factor institutional stability into their planning. What's particularly concerning from this perspective is not any single institutional stress, but the cumulative effect of multiple stresses occurring simultaneously. Courts making election law, legislatures challenging court decisions, executives modifying administrative procedures, and voters losing confidence in institutional neutrality. These pressures interact with each other in ways that can amplify rather than dampen systemic risk. The foreign exchange markets are especially sensitive to these dynamics because international investors have alternatives. When American institutional stability becomes less certain relative to other major economies, capital begins flowing differently. Not in dramatic ways that would constitute a crisis, but in the measured, careful way that reflects changing risk assessments over time. Watson versus RNC doesn't exist in isolation. It's part of a broader pattern of judicial intervention in election administration that reflects deeper tensions about how democratic institutions should adapt to changing circumstances and competing political pressures. Over the past decade, we've seen an unprecedented number of election-related cases reach federal courts. Voting procedures that were once handled through routine administrative processes are increasingly becoming matters for judicial resolution. Redistricting disputes, voter registration requirements, ballot access rules, polling place operations, all of these have become regular subjects of federal litigation in ways that would have been unusual a generation ago. This judicialization of election administration reflects several converging trends. Political polarization has made it more difficult to resolve electoral disputes through traditional political channels. Declining trust in local election officials has led both parties to seek judicial intervention when they view administrative decisions as biased. And increased legal sophistication among political actors has created more opportunities to identify potential constitutional or statutory violations in routine election procedures. The result is a system where courts are making decisions about technical election administration details that they're not necessarily equipped to handle effectively. Federal judges, however capable, don't typically have expertise in the logistics of ballot processing, the challenges of rural mail delivery, or the operational requirements of large-scale election administration. At the same time, state and local election officials find themselves operating under increasing legal uncertainty as court decisions modify established procedures, sometimes with little notice or preparation time. The professional administrators who actually conduct elections, often dedicated public servants working under difficult conditions for modest pay, must navigate an increasingly complex legal landscape while maintaining public confidence in the integrity of their operations. This tension between legal oversight and administrative practicality creates exactly the kind of systemic stress that concerns long-term investors. When institutional roles become unclear, when traditional boundaries shift without clear new equilibria, when technical expertise conflicts with legal authority, the entire system operates less efficiently. The pattern extends beyond election administration into other areas of institutional governance. We've seen similar judicialization in areas like immigration enforcement, environmental regulation, and financial oversight. In each case, political deadlock at the legislative level has led to increased judicial involvement in areas that were traditionally handled through administrative or political processes. Foreign observers pay particular attention to these institutional trends because they affect assessments of American governance capacity. International businesses making long-term investment decisions, foreign governments negotiating agreements, and global financial institutions managing risk all factor institutional stability into their planning. When American institutions appear to be in constant conflict with each other, it affects external confidence in our ability to maintain predictable policies and stable governance. The Supreme Court itself seems aware of these broader institutional dynamics. In recent cases involving election law, several justices have expressed concern about the court's expanding role in resolving political disputes. They understand that excessive judicial involvement in inherently political questions can undermine both judicial legitimacy and democratic accountability. But the court also recognizes that when other institutions fail to resolve conflicts, judicial intervention may be necessary to prevent more serious institutional breakdowns. The challenge is distinguishing between cases where judicial involvement serves institutional stability and cases where it creates additional instability. Watson versus RNC embodies this tension perfectly. The case involves a genuine conflict between federal law and state practices that needs authoritative resolution. but whatever the court decides will inevitably be viewed through partisan lenses by actors who see election procedures as determinants of political advantage rather than neutral. Administrative requirements. The international implications deserve particular attention in our interconnected global economy. American democratic institutions serve as a model for developing democracies worldwide, and highly publicized disputes about election procedures can affect international perceptions of democratic stability and effectiveness. When foreign leaders or international investors see American institutions in apparent conflict over basic democratic procedures, it influences their assessments of American leadership and reliability. As I reflect on this moment in our institutional development, I'm reminded of other periods when American democracy faced fundamental questions about how to balance competing values and adapt to changing circumstances. The parallels aren't exact, but the underlying tensions are familiar to anyone who has studied how democratic institutions evolve under pressure. During the Great Depression, we faced questions about whether democratic institutions could respond effectively to economic crisis without abandoning constitutional limitations on government power. The tension between emergency action and constitutional constraint tested every branch of government and ultimately reshaped our understanding of federal authority. Watergate presented different challenges, whether democratic institutions could hold powerful actors accountable when traditional political oversight mechanisms failed. The crisis tested our constitutional system's capacity for self-correction and ultimately demonstrated both its vulnerabilities and its resilience. The financial crisis of 2008 raised questions about whether democratic institutions could respond quickly enough to fast-moving systemic risks that transcended traditional regulatory boundaries. The response required unprecedented coordination between institutions that had traditionally operated independently. Each of these crises taught important lessons about institutional adaptation and the delicate balance between stability and flexibility that democratic systems require. Institutions that are too rigid break under pressure. Institutions that are too flexible lose their essential character and public confidence in their reliability. Watson versus RNC presents a contemporary version of this eternal tension. Federal election law requires national coordination to prevent the chaos that could result from incompatible state procedures. But state administration allows for local adaptation to geographic, demographic, and practical circumstances that federal law cannot fully anticipate. The Supreme Court must balance these competing requirements in a way that preserves both national coordination and administrative practicality. But it must do so in an environment where every decision will be scrutinized for political motivation rather than evaluated purely on legal or practical merits. What concerns me most about our current moment isn't any particular institutional conflict, but the erosion of shared assumptions about institutional legitimacy that makes resolution of such conflicts more difficult. When large numbers of Americans view courts as political actors, legislatures as partisan battlegrounds, and administrative agencies as extensions of particular political factions, it becomes much harder to achieve the consensus necessary for stable institutional operation. Democratic institutions depend on what political scientists call diffuse support, public acceptance of institutional legitimacy that persists even when people disagree with particular decisions. When that diffuse support erodes, institutions can still function, but they do so under much greater stress and with less capacity to address unexpected challenges. The financial markets provide a useful analogy. During periods of high confidence, markets can absorb significant shocks without systemic disruption because investors maintain faith in underlying institutional structures. During periods of low confidence, even minor disruptions can trigger larger instabilities because investors lack trust in the system's capacity to manage problems effectively. American democratic institutions currently operate in something like a low confidence environment. not crisis level, but elevated baseline stress that makes every institutional conflict more consequential than it would be under normal circumstances. This is why seemingly technical cases like Watson versus RNC carry such symbolic weight and generate such intense scrutiny. The international dimension adds another layer of complexity. In the globalized economy, American institutional stability affects not just domestic governance, but international economic relationships, security, cooperation, and the broader architecture of democratic governance worldwide. When American institutions appear dysfunctional, it affects global confidence in democratic governance as a model for other societies. One of the most fascinating aspects of watching institutional development over decades is observing how human psychology interacts with formal institutional structures to create outcomes that neither law nor economics alone can predict. People don't just respond to institutions as they are, they respond to institutions as they perceive them to be. And those perceptions are shaped by narratives that often bear limited relationship to institutional reality. In the case of Watson versus RNC, the actual legal question is quite technical. Does federal election law preempt state laws that allow post-election day ballot receipt? The answer will depend on complex questions of statutory interpretation, constitutional doctrine, and federal-state relations that most Americans have no reason to understand in detail. But the public narrative around the case has almost nothing to do with these legal technicalities. Instead, it's become a symbol for broader anxieties about election integrity, democratic legitimacy, and institutional trustworthiness. People interpret the case through pre-existing beliefs about whether elections are fair, whether institutions can be trusted, and whether their political opponents are acting in good faith. This gap between institutional reality and public perception creates what I call narrative risk, the possibility that institutional decisions will be interpreted in ways that undermine institutional legitimacy, regardless of their actual legal or practical merits. It's similar to what happens in financial markets when investor sentiment diverges from underlying economic fundamentals. Social media amplifies these dynamics by rewarding the most dramatic interpretations of institutional developments. A routine. Supreme Court order becomes a blockbuster case. A technical legal dispute becomes a battle for the future of democracy. Measured judicial reasoning gets lost in headlines designed to maximize engagement rather than promote understanding. The result is a feedback loop where institutional actors must consider not just the direct effects of their decisions, but also how those decisions will be interpreted, misinterpreted, and weaponized by political actors seeking to advance particular narratives. This additional layer of complexity makes institutional decision-making much more difficult and can lead to suboptimal outcomes as institutions distort their reasoning to accommodate political considerations. The Supreme Court faces this challenge acutely because its legitimacy depends on public acceptance that its decisions flow from legal rather than political reasoning. But in an environment where every decision gets interpreted through partisan lenses, maintaining that distinction becomes increasingly difficult. What's particularly troubling is how these narrative dynamics can create self-fulfilling prophecies. If enough people become convinced that institutions are politically biased, they may act in ways that actually increase political pressure on those institutions, creating the very politicization they feared. In uncertain times, institutional steadiness becomes its own form of leadership. The Supreme Court's quiet, methodical approach to Watson versus RNC, accepting the case without fanfare, scheduling it for normal review, avoiding dramatic language or premature commentary, represents exactly the kind of institutional behavior that builds confidence rather than eroding it. There's something profoundly reassuring about institutions that continue to operate according to established procedures, even when external pressures encourage deviation from normal practices. The court didn't rush to judgment, didn't issue inflammatory statements, didn't allow political pressure to alter its standard review process. It simply did what the Supreme Court does, accepted a case that presents important legal questions requiring authoritative resolution. This kind of institutional steadiness doesn't generate headlines or viral moments, but it provides the foundation upon which everything else rests. Markets value predictability, international partners value reliability, citizens value consistency. When institutions demonstrate these qualities through their actions rather than their rhetoric, they build the kind of trust that sustains democratic governance through difficult periods. The court's handling of Watson versus RNC will ultimately be judged not by the political reaction to its eventual decision, but by whether its decision-making process maintains the institutional characteristics that have enabled the court to serve as a stabilizing force in American governance for more than 2 centuries. As I think about Watson versus Republican National Committee and what it represents for American institutional development, I keep returning to a simple observation. The strongest institutions are often the quietest ones. They don't seek attention, don't chase headlines, don't confuse visibility with effectiveness. They simply do their work day after day, year after year, building trust through competence rather than charisma. The Supreme Court's decision to hear this case and the methodical way it's approaching the complex legal questions involved exemplifies this kind of institutional steadiness. Whatever the justices ultimately decide, their decision will be based on legal reasoning, constitutional interpretation, and careful consideration of practical consequences. It won't be perfect. No institutional decision ever is, but it will be principled. That's what Americans should expect from their institutions. Not perfection, but principle. Not drama, but duty. Not spectacle, but steadiness. The Constitution provides the framework, but it's the daily work of people committed to serving something larger than themselves that makes the framework function. In my 94 years of observing American institutions, I've learned that our system's greatest strength isn't its efficiency or its elegance. It's its capacity for self-correction, its ability to adapt to changing circumstances while maintaining its essential character, and its dependence on ordinary people who understand that institutional responsibility is both a privilege and a burden. Watson versus RNC will be decided by 9 justices who never sought to become symbols, but who understand that their individual decisions collectively shape the foundation of American governance. They'll interpret legal text, consider constitutional principles, and evaluate practical consequences. Then they'll issue a decision that will become part of the ongoing conversation between American institutions and the American people about how democracy should work in practice. The viral clips will fade. The political commentary will move on to other subjects. The headlines will give way to different controversies. But the court's decision will endure, becoming part of the legal framework that guides American elections for years to come. That's the real story here, not the immediate political reaction to legal developments, but the slow, steady work of institutional development. That continues regardless of who's paying attention. The Constitution still anchors our system. Professional public servants still do their work with integrity. Courts still resolve disputes according to legal rather than political criteria. In uncertain times, these quiet institutional strengths matter more than dramatic political gestures. The foundation still holds, not because it's perfect, but because enough people still understand their responsibility to maintain it. And that at the end of the day is why I remain optimistic about American democracy's capacity to meet whatever challenges lie ahead. Not because our institutions are flawless, but because they're inhabited by people who understand that serving something larger than yourself is both the foundation of democratic governance and the definition of true leadership. The work continues. The foundation endures. And the quiet strength of institutional commitment proves itself again through the patient resolution of difficult questions that determine how democracy functions in practice. That's the lesson of Watson versus Republican National Committee. In a noisy world, steadiness is its own form of leadership. And in uncertain times, that steadiness is exactly what the country needs.